there, and welcome to the court case of land alienation. My name is Sabrina. Let's meet the other presenters.
Hello, I am Syasya Syahirah.
Hi, I am Zarifah Rusydina.
Hi everyone, I'm Alif.
Let's begin with a little introduction of land alienation. Regarding our topic, Section 5 of the National Land Code, which also referred to as NLC 1965, has defined several terms. Firstly, land is wider in scope and more in line with the common law definition than that adopted by the Constitution. The definition mentioned about land not only in its physical form, but also its components. The land administration in Malaysia is within the power of the state authority, which also referred to as SA. State authority means the ruler or governor of the state which has the power in deciding the matters with regards to applications relating to land under Section 5 of the NLC. It also provides that state land means all land in the state which includes the bed of any river and of the foreshore and bed of the sea, other than alienated land, reserve land, mining land, and any land that relates to forests. Besides, according to Section 40 of the NLC has vested the power to the state authority over all state land within the territories of the state. Under Section 42(1)(a) of NLC provides that the state authority has power to alienate state land in accordance with the provisions of Section 76. Moreover, the requirements to alienate state land has been set out in Section 76 of the NLC, which stated the general meaning of alienation is defined as an act of the state authority to dispose the state land for a period of term, not exceeding 99 years for perpetuity, in consideration of annual rent, in consideration of a premium, subject to a category of land use, and subject to such conditions and restrictions as the state authority sees fit. According to Section 78(3) of the NLC provides that the alienation of state land shall take effect upon the registration of a registered document of title, although the alienation has been approved by the state authority. The land shall remain as state land as long it has not registered.
Let me introduce the parties involved. As you can tell, this court case is about mengawarti sendirian berhad Persekutuan Pengarah Hasil Dalam Negeri. Mengawarti sendirian berhad, the taxpayer as the plaintiff, meanwhile, Ketua Pengarah Hasil Dalam Negeri, Masa Merdeka Sendirian Berhad as the defendant.
Now, let's continue with the fact of the case, shall we? Mengawarti Sendirian Berhad, also known as the plaintiff, is a taxpayer of house developer. Plaintiff applied to the state government Melaka for an acreage of 250 acres leasehold land for housing development purpose. On 1 February 1980, the state government approved the video notification of the application. On 5 March 1980, plaintiff entered an agreement with another housing developer, also known as Defendant Masa Merdeka Sendirian Berhad under Ketua Pengarah Hasil Dalam Negeri, to develop the land at a cost of 3.5 million must be paid to the plaintiff, which is 850,000 before 1 April 1980. Is the expiry date notification on February 1st, 1980, and the remaining amount of 2,650,000 should be paid in proportion with people in developed areas. On 16 May 1980, the notification is replaced with another notice compelling the plaintiff to pay a total of 858,050 for the land alienation. Then, on 18 September 1980, a qualified title has been issued by the state government. Next, on 31st December 1980, plaintiff and the defendant had entered in another agreement which varied the consideration from 3.5 million to 900,000. The payment was 831,340 within 2 weeks from the date of the letter of approval from the Land Administrator of Melaka Tengah. The balance sum 98,660 must be paid upon completing of the housing estate. On 31st December 1980, the plaintiff balance sheet carried with inter alia at the end of the year. The item of land for development was 831,340 and for the advance which is unsecured was 864,503 ringgit. On 31st December 1981, at the end of the year, the land development was same with the last year and for the advance was 864,600. Then, at the end of the year of 31st December 1982, the land development increased from 831,340 to 858,050 ringgit and the advance increased from 864,000 to 900,000 and reclassified as deferred income. On 8 July 1983, a supplemental agreement was entered into between the plaintiff and the defendant on providing for the payment by defendant to the plaintiff of an additional consideration of 50 cents per square feet when the buildings are complete and sold by the defendant. Lastly, the plaintiff was assessed to tax which were 831,340 in 1982 and 68,600 in 1984. As being discontented, the plaintiff lodged an appeal with the Special Commissioner.
Are you still with us? Let's carry on with the argument of plaintiff and defendant. Firstly, the plaintiff argument. The plaintiff abandoned the disputation that the sum of 900,000 ringgit represented as the advance and admit that it was income but persisted to insist that the land alienation costs were deductible against the income of 900,000 ringgit. Thus, whether the land alienation costs were removed from the income was the only issue before the High Court.
How about defendant's argument? Defendant state to be received an agreement from plaintiff where defendant must pay 3,500,000 ringgit to plaintiff providing for the payment by defendant, which refer masa merdeka to the plaintiff, taxpayer of an additional consideration of 50 cents per square feet when the buildings are completed and sold by Masa Merdeka.
Let's proceed with court decision. As decided by the court, we've been knowing that the existence of the payment of the land alienation cost by the plaintiff to the state government found by the special commissioners has no evidence. Sadly, the finding of the special commissioners was unassailable in applying the established principles set out in Chua Lip Kong vs. Director General of Inland Revenue due to the no evidence of the date and actual amount paid to the state government. Hence, the High Court could neither overrule nor supplement it. Nevertheless, holding that the plaintiff had paid the sum of 831,340 ringgit to the state government in year 1980, the Special Commissioner's finding is directly contradicted to the finding made by the High Court. It assaulted, overruled, or raised the Special Commissioner's finding of primary facts, contrary to the well-known principles set out by Lord Diplock in Chua Lip Kong, which known as Supra. This means the High Court had mistaken on this issue. The Special Commissioner's finding as triers of finders of facts was preferable. Its decision without any error should be proclaimed. Next, even though there was no proof the plaintiff had paid the land alienation costs to the state government in 1980, the judge was right in law as the land alienation costs were capital expenditures for acquiring the land and not revenue expenditures. Besides, those expenditures were not totally and exclusively incurred in the production of plaintiff's gross income of 900,000, nor when the plaintiff received the income in 1981 and 1983. It is clearly stated that such requirement upon all outgoings and expenses must have been totally and exclusively incurred during the time given, also specifically contained in Section 33(1) of the Income Tax Act 1967. Last but not least, the judges were correct in pointing at their conclusions despite the fact that they were on different grounds. As a result, the answer to the sole issue for determination was in the negative. It had been decided that the plaintiff's appeal had no merits.
Here we are, almost done with the presentation. What can we conclude from this court case? From our observation of this research, we can agree that Mengawarti Sendirian Berhad must have followed the law, as the land alienation costs were capital expenditures for acquiring the land and not revenue expenditures. The evidence of the existence of the payment of the land alienation costs to the state government must be clear to avoid any misunderstanding between both parties, which are Mengawarti Sendirian Berhad and Ketua Pengarah Hasil Dalam Negeri. Also, every agreement needs to be significant and comprehensible by everyone, especially when it involves any payment which must be crystal clear. At last, court has decided that the plaintiff had no merits due to the determination made was in the negative. We should adhere to the law of land alienation. For instance of this court case, the land alienation costs were capital expenditures for acquiring the land and not revenue expenditures, as well as follow with what has been stated in the Income Tax Act 1967.
Before we end the video, we would like to show gratitude to our beautiful Miss Shamim for your incredible patience and guidance throughout our ODL lessons. Thank you everyone and stay safe.